Extract of the judge's opening directions.
Ladies and gentlemen, you've been selected to serve on the jury in this case. You've heard the indictment and special defence read out and been provided with copies of these. I now want to explain to you the procedure we're going to follow in the case. You and I have completely different functions today. I have to see to it that the trial is conducted fairly, to decide on any legal questions that may arise, and at the end of the evidence, to set the legal framework within which you reach your verdict. In complete contrast to that, it's your job, and yours alone, to decide all questions of fact in the case and whether the charge has been proved. You're here as judges of the facts, not as detectives, and must decide solely on what you see and hear in this courtroom today. Proceedings against the accused are brought by the Crown. The Crown has to prove the charge. The case for the Crown is being presented by the Advocate Depute, who's sitting at the table with her back towards you. The accused is represented by his counsel, Miss Campbell, who is facing you across the table. There are no opening speeches. We go straight into the evidence. First, you'll hear evidence from witnesses called by the Crown. After swearing that they will tell the truth, each witness will be examined by the Advocate Depute, cross-examined by Miss Campbell if she wishes, and then re-examined by the Advocate Depute if she wishes. Sometimes evidence is agreed or unchallenged. If that's happened, it is recorded in a document that will be read out to you. After the Crown has led its evidence, the accused, if he wishes, may also lead evidence. The defence isn't obliged to do so, but if there is any defence evidence, the order of questioning will be reversed. Each defence witness, after examination in chief, may be cross-examined by the Advocate Depute. That may be followed by re-examination. After you've heard all the evidence, you'll hear closing speeches, first for the Crown and then on behalf of the accused. And it's only after that that I will give you directions to set the legal framework for you to decide if the charge has been proved or not, and then you'll retire to consider your verdict. It is very important that you keep an open mind about this case until you've heard all the evidence and the speeches and my directions. Only after that is it appropriate for you to reach any final conclusions. Please keep in mind throughout the trial that you have affirmed that you will decide this case according to the evidence. Please now listen carefully to that evidence as it is presented to you.
Extract of the judge's closing directions.
Ladies and gentlemen, you've now heard all the evidence and speeches for the Crown and the defence. I've now to explain the legal rules you have to apply in deciding this case. Your function is different from mine. You're the judges of the facts. You decide what's been proved and what hasn't. To do that, you must consider all the evidence. You'll have to make a number of decisions about the evidence in this case, so please keep the following 3 points in mind. Firstly, it's your recollection of the evidence and yours alone that counts. If the recollection of the facts by the Crown or the defence, or me for that matter, don't accord with yours, disregard that and hold by your own. Secondly, your view of the evidence is the only one that matters. And thirdly, I don't intend to go over the evidence in detail. That's not my job. If I refer to it, that's only to draw it to your attention, not because I have any views about it, but simply to illustrate a point.